Good morning, everyone. This is Keith Eastland, and I'm with my partner, Rebecca Strauss. Thanks for being with us this lovely Tuesday morning. The sun is out, and we're going to give you the daily dose of the webinar today. Before we do that, from Miller Johnson, I would like to give you some good news. Well, relatively good news, we should say. Statistically in Michigan, total confirmed cases of COVID-19 as of Monday was 47,552, and unfortunately there have been 4,584 deaths. The relatively good news is that Monday marked the third day in a row statewide that we saw fewer than 500 new cases. And in particularly much better or good news out of Detroit, there was an article in the Free Press yesterday that shared some statistics on the death rate in Detroit. And these statistics, I think, are sobering because these are lives that are lost, of course, and that's horrible. But somewhat, I guess, hopeful in the sense of if you look at the trend. From April 18th through the 24th, City of Detroit had 167 people die from COVID-19. A week later, from April 25th to May 1st, 93 people died. So it went from 167 to 93, almost cut in half. And then from May 2nd to May 8th, the deaths fell to just 41. I don't mean to be flip about that, but it did decrease, and that's good news. So, and they're reporting that they expect the deaths in the city to continue to decrease by 1/2. That's great news. Good article if you want to read it. But I say that because I think the social distancing and other things that many of us have been doing are working, and it's important to be positive whenever we can here. So let's get to today's topic. What employers should do when your employees tell you, hey, I don't want to come to work. This is a common question that we've seen, and we thought we'd do a short webinar on this, kind of go through, give you guys a framework or a strategy to manage this, both the legal and practical risks, and then go through some scenarios at the end, as well as answer your questions. As more and more sectors of our economy open up, we're going to have more and more questions about people wanting to return to work, wanting their employees to return to work, but maybe some employees being reluctant. And Rebecca can comment on this as well. But what I've tended to see is, a lot of workforces, you get a good mix. You get a lot of people that are tired of Netflix and tired of sitting in their house, and they feel comfortable, they want a social distance, they want a mask, and they're ready to work. They're ready to work safely, and those people want to do it. And then you have another complement, and percentages are hard to attribute here, but other people that, well, wait a second, I'm not sure I want to leave my house and expose myself to 200, 300, 150, 90 people at work, whatever the number is. And for many different reasons. And, people watch the news, they're on social media, they're hearing, PSA announcements about how scary this is. So it creates an interesting dynamic for you all to manage in terms of employee engagement and the differing perspectives. So what do you do? I'm proposing 5 step strategy or 5 issues that I think will give us the framework for how we respond when somebody doesn't want to come to work. And we're going to go through each one of those this morning. The first is communications. Second is you got to manage your legal risks. We're lawyers, so we got to tell you about all the bad things that can happen legally. And then third is managing your practical risks. I think in particular, if you can navigate the legal landmines here, great, but there's so many practical implications in terms of perception, employee engagement, even public relations that can come with decisions in this aspect. Nobody wants to be the employer who's on the front page of MLive or a news story, investigative reporter that's, firing people because, they believe it's unsafe to work. And then we're going to talk about some benefit issues that come with practical strategies if you are going to put people off on some sort of leave status. And then unemployment, because we all know, at least through July 31st, if you get unemployment and you're eligible for some level of state weekly benefits, you're going to get that extra $600 on top, which people are like, hey, why wouldn't I take that instead of work? Not everyone, but a good group number of people are taking that position. Let's see. Okay, let's talk about communication. It is critical. Communicate even more. I see this when an employee comes and says, hey, I don't want to work. I think this is an opportunity for leadership and to demonstrate your organization's communication skills. Okay, what do I mean by leadership? Are the leaders out on the floor? Let's say you're a manufacturer. Let's say you got back to work on Monday, or you're getting ready to go back to work. Are the VPs, are the owners, are they walking the floor? Are they there in the trenches, so to speak? I'm sorry, I'm an old Navy guy and a military guy, so that's the way my mind thinks. But are they in there with the workers? Are they part of the team? Or are they sitting up in their office or working remotely and not willing to come in? Now, certainly we have to be careful because we under executive orders, you must limit the number of people needed to work. But I think, having a leader come through for short periods of time, talk to people, shake their hands. I know in the healthcare industry that's particularly effective, right? When, you see leaders in looking at the medical care providers, the nurses, all those folks, standing shoulder to shoulder with them. That's leadership, and that comes from the top down. Communications, okay? Why are we working? Why are we permitted to resume? Make sure your employees understand if you're an essential critical infrastructure, why that's important. And if you're critical infrastructure, you not only can work, you're encouraged to work because it's needed to support our nation and our state in these challenging times. If you're permitted to resume work, make sure you communicate with your employees, why are we permitted to resume work? Well-written recall letters is a bullet point here. You may have seen in the news the CEO of General Motors sent all the workers who would be returning a letter with 5 masks, kind of laying out, what we're doing to keep people safe, right? That's what the workers need to know, your employees need to know is, okay, what are you guys doing? What is the employer doing to keep me safe? We've got to give them assurances on safety. Okay, how am I going to be safe? Well, you're going to be screened. What are we going to be screened? You're going to take temperatures. You're going to, have a questionnaire to fill out. Anybody that has any symptoms or reports close contact with anyone with symptoms is going to be screened off and not allowed into the workforce for the required or recommended periods of self-quarantine. If we catch wind of something in our workplace, these are our protocols. These are our steps to clean, deep clean, disinfect. Talk to your employees. Explain to them how it's going to be different. What are the things you're doing in the plant? Maybe you're going to clean it 3-4 times a day, 3-4 times a shift. Maybe you're going to give every employee at their workstation, disinfectant, cleaning, gloves, PPE. When they hear that, they're going to feel better about that. And then training. Certainly the executive order that Rebecca and I talked about last week for manufacturers, there's required training. But even if it isn't required, hopefully you've done that already or you're going to do that and people understand, and they need to have an avenue where they can bring their questions, right? If I want to come back to work and if I'm a little bit nervous, you're going to tell me all these things, but I also need a mechanism, an opportunity to say, okay, who's going to get my questions answered? And, we don't want it to be, hey, go talk to your supervisor because unless that supervisor is equipped to answer those questions, because that's kind of to me, I look at that and say we don't want it to be perceived as hey, just go talk to your supervisor. No, talk to your supervisor. If you don't get an answer, here's the point of contact. Here's how you get that. And then the last bullet point on here is an idea. Obviously you've got to decide what works best for your employees and workforce, but do you have a town hall? Do you have a Zoom call, multiple Zoom calls where there's question and answer opportunities for people at work? And it makes it a little hard when you have to gather people together because you've got to make sure you're avoiding meetings and any gatherings need to maintain the social distancing, but it's important to have whatever method or platform of communication works best for your employees. So number 1, communicate. But you guys know how to do that. 2, manage your legal risks. So the immediate question that I always ask clients is, well, this person doesn't want to come to work. The immediate question is always, why? What's the reason they are refusing to come to work? And I always say, okay, let's go through and make sure first it's not legally protected. Because if it's legally protected, then we can't, even if we want to, take any adverse employment action or discipline against the person, corrective action. So let's go through some examples of where you can step in this if you're not thinking through this. First is Executive Order 36. Governor Whitmer issued that, oh gosh, it's been a long time now. It's been a couple weeks, if not a month or so. Basically, that provides job protection for 3 categories of individuals. Any person that has COVID-19, anybody that has the principal symptoms, which are atypical cough, atypical shortness of breath or fever, or if you've been in close contact with somebody that has the symptoms or has tested positive, you're also protected. And remember, Executive Order 36 is the one that sets state public policy and directs individuals to stay home and self-quarantine for specific periods during that time. So if the employee that is saying they can't come to work for one of those reasons, they're protected. Okay, what about the ADA? Well, if I have a medical condition that's a disability, maybe it's in an elevated high risk, which we're going to talk about in detail later in one of our scenarios. Do I have an obligation to reasonably accommodate? Well, certainly. If somebody has a disability and they need a reasonable accommodation and they request one, we all know you have to engage in that interactive process. So what are the facts here? Why are they requesting the leave or the ability or refusal to work? Is it ADA related? Okay. Are there FMLA concerns? Is there a serious health condition? Do we have any of the triggering events for Families First Corona Response Act, right, for either emergency paid sick leave or the extended family medical leave under the FFCRA? And again, we've got webinars on the system that cover all of that. I'm trying not to get into the weeds. And we'll get into some of this in our examples and scenarios, but these are all things you need to think through. And also, Michigan Paid Medical Leave Act. Does the employee have the ability to take it for one of those covered reasons, time off for that? Okay, those are pretty obvious ones that most HR professionals will flag in a heartbeat. What about another one that might be a little less obvious? The National Labor Relations Act is also an area we need to manage here for legal risk. We talked about this in the past on our webinars in detail, but there's this concept, right? It's called concerted protected activity, right? So if employees get together, or even if one employee expresses concerns on behalf of a group, and it's about working conditions, and it's for mutual aid and protection, then that is going to be protected conduct. So if Keith Eastland says to Rebecca Strauss, my manager, I don't want to come to work because I think that, it's a meat packing place, and those are just there's no way we can social distance, and these conditions for all of our workers are unsafe, and you guys need to change the way you operate, and you need to give us 6 feet of difference, and unless and until you do, I'm standing up for our rights. Okay, that's protected concerted activity. Even if I didn't act with 2 people and come to Rebecca with 2 of us, right? 2 employees. That doesn't necessarily preclude that because I'm acting on behalf or inciting group action. So I think the facts here really matter, and you need to make sure you don't forget about concerted protected activity under the National Labor Relations Act. And then you also might just have a strike. Hey, we're not coming to work. You saw this in the Amazon facility in Romulus, some other places. People say, you know what, we're not coming to work until you fix X, Y, and Z. Well, if you say you're fired, that's a real legal problem. Now, you could say, well, okay, you're on strike, and we'll talk about a little the things you can do when employees on strike later, but they can't just automatically be fired. That's protected activity, and you need to stay away from being hauled before the NLRB with an unfair labor practice charge. And then OSHA, safety concerns, right? If I'm raising legitimate safety concerns, again, this gets back to the number one, which is make sure you communicate why things are not unsafe, right? If someone raises safety concerns, we certainly don't want to retaliate against somebody for raising those concerns, and we want to make sure that they understand exactly how you're complying with all of the government directives and what you're doing in addition to that to keep people safe. But that's certainly an area of legal risk. Okay. What about the practical risks? Okay, so let's say we get through the legal risks. None of this is protected. It's just because Keith has an irrational fear or is lazy and wants to watch Netflix all day. He'd rather collect unemployment, right? And it's not protected. Well, I think there's some practical considerations that you need to think through. What about employee engagement? Need to keep talent. You might have people that are legitimately worried about this, and maybe you've spent a lot of time training them. Do we really want to say you have to come back or your employment's going to be over? Maybe you do, maybe you don't. Again, what are the facts? Think about this scenario. What if Keith's not coming to work because he has, a 7-year-old who is in the middle of chemotherapy treatments for leukemia, and he needs to make sure that it doesn't put his son or daughter at risk. Okay, that's probably not protected because it's a child that is in a high risk category because they're immunosuppressed based on the chemotherapy treatments, and that's a sympathetic cause. Do we really want to say to Keith, yeah, too bad for you? You get your what to work or else? And then he goes, Keith, you got a friend who writes an article about that? Is that really the message we want to send? And think about the impact on your other employees. What messages are we sending? And I think this is a difficult thing for HR folks to manage because at the same time, you need people to work. You need people to get things done so you can run your business and continue to provide living and a good wage and benefit package for all your people. But at the same time, you have to account for sort of the facts and individual circumstances and how that's going to create a perception both among your employees and then externally to your organization. Okay. And then consistency, right? We always have to think about, if we consider practical risks, well, what are we doing for ourselves in terms of consistency when the next person makes the request? Can we draw a distinction that is both lawful and makes sense to employees? Why would Keith be allowed to take some leave for his son with leukemia, but not Rebecca for whatever reason she brings? So we want to make sure whatever path you guys carve out for your organizations, you do it consistently and think about, okay, what's the impact if I make this decision in this case on the next and the next and the next down the line cases? All right, that's some of the practical risk considerations. All right, let's talk a little bit about leave, discipline, or discharge. Okay, a lot of what I've been counseling clients on is the situation where you don't want to necessarily lose your talent. You don't want to send a message that, hey, look, we're not willing to work with you if you're legitimately worried about coming to work. So what about a temporary leave of absence? Can you accommodate that? Does that make sense? Can we say to Keith, look, I know you're upset, you're worried, you think this is, can we give Keith a couple weeks off and say, okay, we're going to expect you to come back? Well, certainly that's likely an option, but what if it's indefinite? What if Keith says, well, I have to stay off until this ends? Well, everybody keeps talking about the new normal, and this may be here for 12 months, 18 months, 24 months. Do we have to continue to accommodate Keith? Well, legally, if you're not in the ADA world, or even if you are, indefinite accommodation, even if you have a disability, indefinite leave is not a reasonable accommodation. So certainly you don't have to do that. But you need to think through these things. How are we going to manage the one-offs, and what is our policy going to be on leaves, and are we going to require them to be definite or indefinite? And remember, no good deed goes unpunished. So if you start to allow indefinite leaves as a reasonable accommodation, then you got to justify why you're not going to do it, a year or two later in a different context where the ADA is implicated. That's going to be used against you. So those are the things to think about. Okay. If we can show the facts that, look, this is someone that just doesn't want to come to work, then I think, and it's not legally protected, then certainly you have every right to consistently apply your attendance policy. If you have voluntary quit provisions in your employee handbook, or of course if you're unionized, you got to follow your collective bargaining agreement and your work rules that are promulgated under the labor contract. But you can deem folks voluntary quit. I would caution that you make sure you've thought through all these things and the practical and legal risks before you just automatically start pulling that trigger. And also remember, if it's protected strike activity, so if people are withholding their labor from you, and we want this, and this corrected, and I'm not coming back till it is, you have the right to permanently replace those strikers. So if they're, you could say, hey, look, you're not fired, but we're going to rehire or hire for your position, and when we hire that new person in, we're going to hire them as a permanent replacement, which means, Keith, and your group of people that are refusing to work because you're on a little strike, that's great. That's protected activity. You stay out there on strike. When you offer to come back to work, because I permanently replaced those positions, you can get in line and wait until the permanent replacements leave or we have an open position for you. So that's another thing to consider as you move through this. So bottom line, have a plan. How are you going to address these things? Every time someone refuses, nail down the facts so you can manage the risk. All right, benefit issues. So what happens if you decide, okay, we're going to put somebody on leave? Well, can we incentivize somebody to come to work in a way without ending their employment relationship so that you don't look like, the big, bad, evil employer? And I think there are some options here. And so if you say, okay, Keith, you don't want to come to work, that's fine. But you have to realize a couple things. We're going to put you on a leave of absence. But during that leave of absence, you're not going to get any pay because you're not working, unless, of course, you're eligible for one of the protected leaves that many of you already know about. Then you also may not need to continue their health care, right? So you got to look at the leave of absence. If you give discretionary leaves and other circumstances and you don't give health insurance or continue health insurance under those leaves, then you can discontinue mine if you consistently apply that. And think about that. That may actually deter me, especially in this world, in the pandemic that we're in. I mean, if I need health care for my family, if I'm really worried, that could be a nice little nudge for me to say, well, I better get back to work because, yeah, my employer is willing to give me a leave of absence, but I'm going to lose health care or I'm going to have to pay for it and pay the 102% under COBRA. I think that's an option that is available depending on your facts. And then the last point here I would say is, look, remember that we read the papers. I mean, people are predicting significant economic recession, if not potentially a depression, which would be horrible. But the reality is we don't know what the number of jobs are going to be in 2, 3, 4 months. And, if we eliminate positions because, people self-select and they don't come to work, let's say you have 10% or 15% of your workforce, you may discover you don't need that many people to operate. You may have had some excess positions in there. And certainly the people that have worked, you can reward those people without, we don't have to get rid of them. Now, of course, if you were to have a collective bargaining agreement, something like that, you may have seniority that governs layoffs, that sort of thing. But if you're a non-union employer, it's perfectly lawful to reward the people that stuck with you and worked through difficult times. And so that's another, I guess, sort of little carrot and maybe part of the communication piece when people are deciding, hey, I don't want to work. Well, make sure you map out and sit down with them and explain the different options and what could or couldn't happen. Go from there. So the last piece I want to talk about is unemployment issues. In ordinary times, a refusal to take on available work, it's a voluntary quit, and you don't get unemployment. And that still should be the case, and actually I think it is the case. I think employers can take that position. I think that there is a good argument for that under the current executive orders, but I caution you to remember that the unemployment agency is deciding this, and they may take a broader view of who gets unemployment and who doesn't, maybe not, but it's possible. And I think at some point in time, a couple weeks ago, the governor suggested in one of her press conferences that if you just refused to stay home, that you would be eligible for unemployment. Interestingly, if anybody watched her press conference yesterday, she raised that question and talked about, well, what if you don't feel safe going back to work? And then she raised the question, and then in my humble opinion, she sort of dodged it by saying, well, if you're protected under Executive Order 36 in one of those protected reasons, well, then you get unemployment and you can stay home. You don't have to go to work. But she didn't really answer the question of, well, what if you're not in, what if you haven't tested positive, you don't have symptoms, you don't have close contact? What about that? She was almost suggesting, well, by not answering it, to me, that suggests, well, you wouldn't be protected, because I think that's the correct reading of the executive orders. There is a little wrinkle with Executive Order 2020-57. That's the expanded unemployment reasons. Just a review for everyone real quick. If you're on a leave of absence because you are self-isolating or you're self-quarantining in response to being immunocompromised, you would be eligible for unemployment. But again, you'd have to show that I'm doing this, I'm not going to work because I'm immunocompromised. Obviously, if you have symptoms or if you've had close contact with someone in the last 14 days with a confirmed diagnosis, or you need to care for someone at home, if you have family care responsibilities because of a government directive and the person that you're caring for also has a confirmed COVID-19 diagnosis, then you'd also be eligible for unemployment. You don't also have to actively be seeking work under Executive Order 57 to get unemployment. But I think the bottom line to me is when you look at all that, I still don't think that you're eligible for unemployment if you simply don't show up for work because you're not comfortable. Okay? If you're not comfortable, you're refusing available work and you don't get it. And as Rebecca reminded me before this webinar, the Department of Labor Secretary for the federal government, Eugene Scalia, has said if you refuse available work, you are not eligible for the extra $600 federal benefit, which is a very important fact that you can tell employees who are thinking, hey, I'll get my $600 plus my state benefit, and I'll make as much or more, so I'm not coming to work. If they refuse available work, they're not entitled to that $600. There may be criminal penalties for that, and they may be walking away from their job for the long term. Okay, so bottom line, you can tell employees that they may not be eligible, and certainly you may want to challenge anyone that applies for unemployment depending on the facts. One other last point, just very minor before I hand it over to Rebecca here, is that if somebody is on strike, there is a disqualification provision in the Michigan Unemployment Security Act that says striking employees are not eligible. They're disqualified from receiving benefits. So that may be another legal arrow in your quiver if you decide to fight unemployment on these issues. All right, I'm going to stop talking and I'm going to ask Rebecca to give you guys or walk through some example scenarios. So Rebecca, let's start with scenario one. Rebecca, you call off work and tell your supervisor that you think it's unsafe to work, and you've got a daughter with asthma, and you just want to stay on layoff until this mess is over. What do you think?
Thanks, Keith. Let's take this piece by piece, and I know this addresses at least one of the Q&As we already got to. What if an employee calls in because of a generalized fear of coming to work, right? It doesn't have anything to do with her own underlying conditions or anything like that. But as Keith mentioned, she's been watching the news and seeing all the PSAs and all the memes on Facebook that if leaving her house could cause other people to die. And the only way to keep us all safe is to stay home. And that's why she wants to stay home. There is no protection, job protection for the employee in that situation. And as Keith mentioned, we don't think she would be entitled to unemployment either. So you as the employer then are faced with the choices that Keith very helpfully laid out for you. Do you want to terminate her employment, which you have every right to do, or do you want to put her on a leave, either with benefits or without? And then when this matter passes or when she feels more comfortable, if there is work available for her, she can come back. I won't rehash everything Keith just said because, frankly, I can't say it as well as Keith did. But I do encourage you to think about your operational needs, whether you actually do need to trim your workforce now anyway, because business is slowing down or that's what's forecasted. And if that is the situation, maybe some people will self-select out, if you will, self-select a layoff situation. So that is a question, again, that it came up in the Q&As here just during this webinar. It has come up on just about every webinar during the last week or two. I know it's on all of your minds. This generalized fear of leaving the house and going back to work, that is not a reason not to come to work, okay? But next, there's another twist, right? What if she has a daughter with asthma? Asthma is one of the CDC's recognized higher risk categories. Okay, that means that folks, and the next example, I'll go through all of those categories with you, but if you fit into one of those categories, you're at higher risk of developing very serious illness if you contract COVID-19. Note in this example, it's not the employee who has asthma, but her daughter. For those of you that have studied and memorized the ADA and all of its guidance and the cases that have developed under it, you know that there is no duty to provide a reasonable accommodation for folks with associations, who have associations with people with disabilities, right? The duty to reasonably accommodate has to do with the employee who has a qualifying disability, not an employee's relative who has a qualifying disability. So you have no legal obligation, frankly, beyond the first part of this paragraph, okay? So you can flip back to what I said just a moment ago. You have the choice to terminate or to put on some sort of leave. This is tough because the governor has actually said if you have people in your home that are high risk, you need to be extra careful about what you do and whether you decide to leave your house. So this is a real difficult situation for your employees in this situation. And frankly, from an employee relations standpoint and a PR standpoint, this might be a situation where you strongly consider a leave of absence, right? You don't need to pay the person. You could put them on paid leave, but it could be unpaid leave, but at least they have a job to come back to, assuming there's work available once the crisis passes. Okay, next slide, please. Right, the next example, this has to do with Keith refusing to work. Keith refuses to work because he has serious concerns based on what he read on the CDC website. He has several pre-existing health problems. He is immunocompromised, has high blood pressure, and is 67 years old. He is at high risk for serious complications if he contracts COVID-19. That's true. He is at high risk for developing severe complications if he develops COVID-19, according to the latest CDC guidance. As you know, the guidance, CDC and otherwise, keeps changing, but as of this morning, when I checked it, the high-risk categories identified by the CDC are being 65 and older, 65, being obese, having a heart condition, asthma, lung disease, diabetes, kidney disease, liver disease, or being immunocompromised for any number of reasons. Immunocompromised can be because you have a condition that suppresses your immune system, or you can be on medications or chemotherapy or those sorts of things that artificially suppress your immune system. So what do you do with an employee in this situation? Hopefully most of you, when I asked that question, thought of the ADA, right? And if you weren't going to think of that anyway, hopefully after my explanation as to example one, you thought of the ADA. Okay, so this person certainly has qualifying disabilities under the ADA. Age is not in itself a qualifying disability, but having high blood pressure would, and most of the other items on that list that I just read to you would be qualifying disabilities under the ADA. So what he is doing, what Keith is doing, without using the exact words, is he is asking you to consider accommodating him, providing a reasonable accommodation. This is a request for a reasonable accommodation, right? He's got a qualifying disability, and he is tying that to a work situation. He doesn't think he can come to work in person, right? Because it puts him at risk. So then you flip into the reasonable accommodation world, which, as most of you probably know, involves the interactive process. We recommend you have the employee fill out a reasonable accommodation request form. We have developed one of these just for COVID-19 high-risk situations. They explain why they are at higher risk, and they explain what accommodation they would like you to provide. And now we're back, frankly, into kind of traditional ADA world. When an employee suggests an accommodation, you don't need to provide that specific accommodation. Certainly consider it. If there are other accommodations that would work equally as well and is better for the employer, you can certainly choose to implement that accommodation. The EEOC last week published additional Q&As on COVID-19 issues and provided several regarding the reasonable accommodation process when someone is at high risk and what types of accommodations might be possible. They include, providing a different workstation, which provides additional distance from coworkers, for instance, additional PPE, maybe working from home on an extended basis instead of having them come to work, even though otherwise they would be back in the office, those sorts of things, okay? What if none of those accommodations are possible for Keith? So the only accommodation that could work for him is not to work at all. Is that a reasonable accommodation you have to consider? A leave under the ADA, remember, has to be for a finite period of time. An indefinite leave is not a reasonable accommodation, the way the law has developed up until this point. Strange facts make strange law, right, as I like to say. So the law may develop out of COVID-19 cases that may change things. But the way they stand right now, an indefinite leave, the kind of leave where someone really doesn't know when they're going to be back, is not a leave you have to provide. I don't know about you, but I don't know when this risk is going to pass. I don't think anyone can give us a date certain when they will say, yes, as of this date, COVID-19 will not exist in our community, right? Keith can come back and be guaranteed that no one with COVID-19 will be at the workplace. I don't know what that date is. I don't think anyone does. So a request for a leave in this scenario, by definition, is a request for an indefinite leave. That's a tricky situation because of all the reasons Keith explained during his part of the presentation. This is an area where you're going to want to tread very carefully. And even though we can make the argument for you that a leave is not required by law, you're going to want to do everything you can to provide a leave for Keith, right? Because this is, again, I don't know how the law is going to develop in this area, and this is going to have, significant negative impact on your other employees and potentially PR and morale, just morale in the workplace if you don't grant Keith leave if none of the other accommodations work. But remember, consider all the other different types of accommodations that are possible other than a leave. Okay, next slide, please. Let's talk about David. David is not a great worker, but he is your only licensed electrician, so you need him. And he says he's not coming back. He can make way more money on unemployment. Okay, this is the problem we all envisioned when the CARES Act passed with that extra $600 kicker. This is not a valid reason to refuse to come back to work. Okay, so you can terminate David's employment without any legal risk. Well, a lawyer should never say without any legal risk, right? With very little legal risk that we cannot identify at this moment. But before you go ahead and terminate David's employment, you may want to counsel him a little bit because you do need him, right? He's your only electrician. So you may want to counsel him that if he turns down this offer to come back to work, that his unemployment benefits, your understanding that he'll no longer be eligible for them, right? So they will end as of that week you offered him back his employment. You may also want to tell him that the extra $600 unemployment benefits that were part of the CARES Act expire on July 31st, right? So if he decides to take unemployment and that extra $600, and assuming for some reason his benefits don't get cut off because he turned down work from you, they will end as of July, the extra $600 at least will end as of July 31st, and then he'll be out that $600 and he'll also be out of a job, and it's going to be real hard to find a job with the type of economy most experts are predicting, either a recession or a depression. Okay, so that's we expect folks to have this attitude, but that's from an employer's point of view, that's fairly an easy one to address. Next example, please. Patrick. Patrick is a single dad with school-age kids. He tells you he can't come to work because Michigan schools are closed and he needs to take care of his children during the day. What do you do? Okay, childcare needs, because school or childcare providers are closed, is a valid reason, qualifying reason for unemployment benefits right now. It's not usually, but under the executive orders Governor Whitmer issued because of the COVID-19 crisis, it is. So he can refuse to come to work for that reason, apply for unemployment benefits, and he will get them. It is also a qualifying reason for benefits under the FFCRA. Why is this question on the slide? Does it matter if you have 500 employees or less? Most of you have heard us say this a lot by now. The FFCRA applies to employers who have 500 employees or less. Most of you have figured that out by now, right? If you are covered by the FFCRA or if you are not. If you are covered by the FFCRA, Patrick is entitled to both types of leaves under the FFCRA. So he'd be entitled to the 2 weeks of Emergency Paid Sick Leave Act, and then the additional 10 weeks of expanded FMLA. Okay, so not being able to come to work because of childcare is a valid reason not to return to work, even when you have work available for people. Now, can you ask employees, well, wait a minute, don't you have a spouse who doesn't work that can provide childcare? Wait a minute, what if we can just have you back part-time so that maybe your spouse is also part-time, so maybe your spouse can take half the day and you can take half the day? Wait a minute, what if we shift your hours, right? So you can work a different shift so that your spouse can be with them part of the day and then you can be with them part of the day. Are you entitled to have those conversations with employees? Yes, you are. But at the end of the day, if Patrick just cannot come back to work because of childcare needs, then that is a valid reason not to come back. Next slide, please. What if an employee calls off and reports he has an atypical cough? And by the way, that's exactly how employees talk, right? When they give you a reason for not coming in, they say an atypical cough. That phrase comes from Executive Order 36, the atypical cough. So an employee calls in and says he has an atypical cough and a little trouble breathing when he's walking upstairs. What do you do? The question is, first, are these COVID-19 symptoms? The answer here is clearly yes, right? EO, Executive Order 36, identifies the symptoms as a fever, an atypical cough, or atypical trouble breathing, okay? So and you only have to have at least one to qualify under EO 36. So clearly he qualifies under EO 36. Under EO 36, an employee has the right to stay home if they have any one of those symptoms, and they stay home until 3 days have passed since their symptoms have been resolved, or 7 days have passed since their symptoms first, and 7 days have passed since their symptoms first appeared. Okay. Hopefully this is not shocking to any of you, not only because you're aware of EO 36 by this point, but I am guessing you have instructed your employees that if they have a symptom of COVID-19, you want them to stay home, right? Never has there been a time where where it's been more extreme, or when someone coughs around you, everyone freaks out. You do not want an employee in your workplace that has any of these symptoms. If you are a small employer, an employer of 500 employees or less, this employee would fall under the FFCRA's emergency paid sick leave provisions, right? The 2 weeks of paid sick leave, and that is protected leave. So you have to allow them to stay home, not just because of EO 36, but also because of the FFCRA. For employers with more than 50 workers, remember the Michigan paid sick leave might require paid time off for this reason. Okay, next slide, please. Let's say that Sally tells you that she has had contact with someone who tested positive for COVID-19. What do you do? Under EO 36, the employee has the right to stay home until 14 days have passed since the last close contact with the sick or symptomatic individual, or the symptomatic individual receives a negative COVID-19 test result. So these tests are speeding up, right? For a while, if you remember, it took sometimes a week to get test results. That's certainly when EO 36 was drafted. Now test results are speeding up a little bit, so this distinction might not be meaningful anymore. But they do have a right to stay home. This would be a qualifying reason under the FFCRA. So for smaller employers, 500 or less, Maggie would qualify for emergency paid sick leave, that 2-week sick leave. That's part of the FFCRA. Let's talk about Sally and let's talk about Maggie for just a moment too, because she would be entitled to unemployment benefits. So the expanded unemployment benefits under EO 57. Some of those reasons include contact with a person with a positive COVID-19 test, also includes if you have a symptom of COVID-19. So in the last example too, both of those employees would be entitled to unemployment. Okay. All right, next slide, please. This is you've probably heard us talk about this if you've been on a webinar in the last week, but Miller Johnson has developed a Back to Work Resource Center, which has lots of the things we've talked about. It has the reasonable accommodation forms, it has the FFCRA request forms, et cetera, training resources for your employees, et cetera. I don't want to dwell on that. I encourage you to look at it and to explore what is available there. But Keith, we have 23 questions that have come in. I am sure we've answered some of them just in the course of going through the examples and what we've said, but let's take a look at the questions now and see what's on your minds and what we can help you with. Yeah,
I'll fire off some to you if that's all right.
Yep, absolutely.
So a couple questions on pregnancy. Is pregnancy among the current CDC categories putting people at high risk and entitling individuals to additional protection? And what if you make reasonable accommodations for someone who's pregnant and they still refuse to come to work?
Okay, so pregnancy is not currently on the CDC's list, although I've certainly heard the stories in the news, and there was just a long segment on CNN yesterday about pregnant doctors and the accommodations they were requesting. So I understand why you're asking the question. I've certainly heard it out and about there. It is not listed by the CDC. So if you do not offer reasonable accommodation to a pregnant employee and that pregnant employee sued you, Keith and I would defend you. However, is that the right thing to do in the current environment, and keeping in mind that the guidance changes frequently as the science, as the research develops, right? I cannot tell you whether that will be included on the CDC page next week or tomorrow or later today. I just don't know if that will happen. It's entirely possible. Right now it's not. So the best practical answer I can give you is to think of it as if it were a defined high-risk category right now and see what kind of accommodation you can provide to that employee. Okay. The second part of that question, Keith, I think was what happens if they still refuse to come to work? If you have provided an accommodation, offered an accommodation that you are confident is a reasonable accommodation and will stand up in court as such, and the person refuses to come to work still, that is a valid reason to terminate employment, right? Because now this person is refusing to work even though they can work with a reasonable accommodation. And that's kind of the hard answer. Flip back to the earlier part of this conversation this morning and think about whether that is something you want to do or whether you want to consider putting that person on leave, which is certainly might be more favorably viewed by coworkers. Okay. All right, next.
Sure. So a couple questions on teleworking or employees working from home. In other words, I know some businesses have been able to allow people to work from home and function, but they prefer them to come back to work. So can you require employees who are working at home to come back?
If you need them in the at the facility to get the job done effectively, yes. But the current state of affairs we're in right now, the executive order still requires you to allow people to work from home who can do so effectively. Okay, so we're not fully back yet. None of us are, no matter what industry you're in. Even if you employ critical infrastructure workers and essential workers, even in those industries, individuals that can perform their work from home should still do so, right, until we get to until we get to even lower numbers of COVID-19 in the community. Okay, Keith, can I ask you one?
Sure.
This is from Jason. What if an employee comes to work but refuses to wear PPE, face masks? And we know that's a hot issue right across the country right now, people not liking being forced to wear face masks.
Right. So I would say that if you're under the executive order, if he cannot consistently maintain at least 6 feet of social distancing while they work, then they are required to wear the mask. It's a part of the job. Absent some medical condition or reason that the person cannot do that, maybe offer a face shield, maybe some sort of a reasonable accommodation. But at the end of the day, if they're not willing to do it and you need them to work in that particular role, I think that you can make them do it, or you can send them home. And if they refuse to follow a safety order, and it's not, they're not doing it because of some protected legal reason that we talked about, then they open themselves up for corrective action or discipline. Do you agree?
I agree with you 100%. I'm going to ask you one more, and then you can flip back after me. But this one is from Will, and he specifically addresses it to you. So I'm definitely asking you. Hi, Keith. EO 36 has a 7-day period outlined, right? So 7 days, and this wasn't said in Will's question, but 7 days since the date of the first onset of a symptom, right, is what Will is referring to. EO 36 is a 7-day period outlined. However, the CDC has now revised its guidance and has a 10-day waiting period after a positive symptom or close contact. Do you expect the governor to update her order?
So I would say I would expect the governor to update her order consistent with CDC guidance for sure. and especially if it's a longer period. My recollection of that, and maybe I missed something here, and if I did, Rebecca, you can jump in here, but my understanding of the CDC guidance, I think it came out May 2nd or 3rd, was the 10 days was for healthcare providers. I hadn't seen if that had been extended to everyone. If it has, I overlooked that. And if it has, then I definitely think Governor Whitmer would extend it. But I think currently the 7 days is applicable to non-healthcare provider workers.
Yep, and I would just add on to that, keep in mind that the CDC guidance is guidance, but it's not legal authority, right? It's not the law. And the executive orders, I know, Keith, there are some legitimate disagreements about this, but it is the law of the land. There's obviously a lawsuit challenging that, about whether the governor has authority to do it. But for our purposes, we should think of it as the law of the land, unless you have a very strong business reason not to, and then call your legal counsel to discuss those risks. Okay, what do you have for me, Keith?
Question on what if somebody uses up all their emergency FFCRA, emergency sick leave, but then has another qualifying reason? Can they take it twice?
No, you get 2 weeks total. And I'll just expand the question. If they have a qualifying reason, which is childcare, for expanded FMLA, keep in mind that 12 weeks of expanded FMLA is part of FMLA. So if someone has already taken 6 weeks during the previous 12 months for something completely unrelated, then they would only get 6 weeks of expanded FMLA. But do remember that the emergency paid sick leave is in addition to any PTO or other leave benefits that they get from you. So they get one emergency paid sick leave, but they do get other sick leave that you may offer in addition to that new federal benefit.
Okay. How about FMLA in general? A couple questions here from different folks on the webinar this morning about when can FMLA be applicable? Might you get FMLA, say, in this scenario where, you have a child with asthma and you want to stay home to care for that person? I mean, we have the FFCRA reason for expanded FMLA, but what about traditional FMLA reasons? When might they apply?
Yeah, that's a great question because even though we have the FFCRA, that did not obliterate the traditional FMLA. FMLA continues to apply just as it would. So an employee would qualify for FMLA for a serious medical condition or to care for someone, a family member with a serious medical condition. Okay, so if they are actually seriously ill, the employee, with COVID-19, such that illness qualifies as a serious medical condition, they would qualify for FMLA. If they are staying home to care for a family member who is seriously ill with COVID-19, such that it qualifies as a serious medical condition, they would qualify for FMLA. It's an interesting question that has not been answered by the Department of Labor or the courts yet, but let's think about the following. An employee who is high risk for developing a serious illness and wants to stay home because of that. My personal opinion at this point, subject to change based on what guidance we get, which will hopefully be soon. Right now, I do not think that is a serious medical condition qualifying an employee for FMLA. Okay, subject again to change as more guidance comes out. There is an argument to be made. So if you have that situation, I suggest calling legal counsel to talk through the specifics. But it's probably not a serious medical condition. The employee that stays home because the child has asthma, assuming the child is not actually ill and requiring care, but the employee wants to stay home because they don't want to put their child at risk, that would probably not be a qualifying reason under traditional FMLA. Again, that answer is subject to change as things develop. I hope that answers all of your questions on that.
No, that's very helpful. Looks like we are at 9 o'clock. Let's do one. I'll answer one quickly, and then I'm going to ask you one more,
Yep.
Rebecca, and then I think we ought to sign off and let people get about their business, and certainly we can be reached after the webinar concludes with additional questions. So one question was, just because a person is eligible for unemployment for child care or for some other reason, does that mean they are protected? Remember, the answer is no. They are separate analyses. Just because you are eligible to take unemployment under the expanded executive order does not mean you're legally protected from your job. Those are two separate analyses that you should do, and you should do the job protection analysis first and then worry about the unemployment after that. And then I'm going to ask you one, Rebecca, before we sign off, and it relates to example 6. This question is, we simply take I think it's Maggie's word for it, that her friend was positive, question mark? Is that what we do? We just take her word for it? Shouldn't we be asking other questions about, is this really close contact? Can we require her to provide some sort of evidence?
Boy, is that a good question, and drives HR people nuts and drives your employment lawyers nuts too. Because I will tell you the answer runs against everything we hold dear to our hearts when we tell you to document everything. Okay, EO 36, Executive Order 36, provides a protected right for that employee to stay home if they have had close contact, that's within 6 feet, for I think it's about 10 minutes or more, of someone who is symptomatic or has a positive COVID-19 test. And Executive Order 36 says an employer cannot require documentation. Okay, I know you don't like that answer. I don't like that answer. Keith doesn't like that answer. Not a lot of us do, but that is what the executive order says. We have had some discussion about whether we can request documentation, but then if we don't get it, we still have to allow the person to stay home, right? So we can't negatively impact the employee's status with us because they don't return it. There is definitely a good argument that you can at least ask, but just remember, if they don't get it back to you, they are still entitled to stay home. Okay, I hope that answers your question. Guidance under the FFCRA, by the way, in a recent Q&A, gave a similar response. They want to make it, the state and federal governments are aligned here. They want to make it as easy as possible for employees to stay home. They want employees to stay home if they've had contact. So they want to make that easy and not difficult. They also don't want to overwhelm doctors with being requested for notes for work and that sort of thing. Keith, what do you think?
I think that's outstanding. Yep. Great. Appreciate all your expertise in answering these questions, Rebecca. I think it's 9:03, so we went a little over an hour. We apologize for keeping you. But again, thank you very much for your participation, and hopefully you'll be able to join us on future webinars. Got some other non-employment webinars lined up this week, and then if you're interested, check out the resource page. I think there's some valuable additional things there that many of you may benefit from. So thanks again for your participation, and everyone have an awesome day.
Thanks, everyone. Bye-bye.